afternoon, everyone. We're going to go ahead and get started. My name is Michelle Nelson, and I'm the social media content specialist here at Field Routes. Thank you for taking time out of your day to join us for employment law, tips, resources, and more. Joining us today is Tammy Comproni, owner of California HR Connections. Before we get started, I'll give you a little bit of background on Tammy. During her 12-year stint with Orkin Pest Control, Tammy Comproni grew her office manager job into a management position where she received her first exposure to employment law. She immediately wanted to learn more, so she joined Isotech Pest Management, taking on a role in human resources management. As the company grew, so did her knowledge of human resources, earning a PHR certification as well as a certification in California employment law. But it was when Comproni's peers began reaching out for help that she realized these certifications weren't enough to maintain compliance with ever-changing employment law. She also saw the industry had a need for someone who understood both human resources and the pest control industry. So she took a leap of faith and started HR for Pest Control and California HR Connection. Comproni now brokers an online, on-demand HR platform that provides resources and support accessible at any time and anywhere by anyone with a need for reliable and compliant HR information. Welcome, Tammy.
Thank you, Michelle.
Our pleasure.
I'm excited about today's presentation, so thank you for that introduction, and thank you to everyone who's tuned in today. So if I may begin sharing my screen here. Let's do that. Bear with me, everyone here. Okay, can we see my screen? Wonderful, wonderful. All right, so thank you, everyone. Let me see if I can get a little video here. Okay, so again, I'm excited about today's presentation, and circling back on that previous employment, the majority of my working career has been in the service industry. I worked for a plumbing company and a uniform provider. When I was at Orkin, I actually spent about a year in the field as a pest control technician, and that was to gain that greater understanding of that field work. And so I could move into that side of management with Orkin. And my career changed a bit after I got involved in a situation that involved employment law. And I found it to be very interesting. And I never thought it would lead me to opening my own HR service and assisting companies in employment law. I know it says California, but don't let that name throw you off in regards to today's webinar. Today, we're going to focus on topics that are across the board. I have clients who have remote employees in other states, so I understand the importance of being able to have a resource to research those laws. And as Michelle stated, I am a broker for an HR platform, and it is the one I use for my business. Okay, so hopefully today I can provide you with some HR tips, best practices, and resources. So let's get started. We'll start with a disclaimer. California HR Connection is not a law firm, and as such does not provide legal advice. Rather, we provide best business practices in accordance with the laws. The content and statements in this presentation is for informational purposes only. It should not be construed as legal advice or service-specific guidance. You should consult knowledgeable legal counsel for any legal questions you may have. All right, so our agenda today is quite a bit to cover, and I'm going to do my best as we move along. Each one of these could be an hour-long webinar on their own. Employment litigation is extremely expensive, and the best way to avoid it is don't make the mistake. And so again, hopefully I can help you with those resources and tips to help you get compliant or stay compliant. So let's get started with this general overview. So why is HR resource important? You cannot by yourself know everything, but having a reliable resource and staying up to date is imperative. The courts are not going to give you any special preference based on the size of your organization. The assessment is going to be based on the violation brought against you. And if you go to trial, a jury will pretty much be in favor of the employee, and that you didn't know will have no merit. You should have known. And can you minimize your liability issue? Yes. You'll need to show you made an effort to follow the employment laws of your state, county, or federal, whichever apply to you. Have a handbook, documents, pamphlets, posters, training for your staff. And then we have safety and risk management. We have OSHA, and everybody's heard quite a bit of that during the pandemic. And you may be one of the 22 states that have your own OSHA plan. If you go to the calosha.gov website, there is a drop down and it gives the list of all those 22 states. I'll give you that link at the end of the webinar. And here in California, I know that with CalOSHA, we actually have a COVID-19 prevention program that we're required to have. Each business should have this within their workplace. I understand that OSHA is making some visits to locations just to see if they have this at their location. If not, there's a proposed penalty. And CalOSHA, with regards to COVID violations, they are posting the company name and address on their website, so it's public, and this is definitely not a list you want to be on. Employee engagement and productivity. When employees begin that first day, the first day on the job, they want to know that they're part of the team. They want to know what their guidelines and expectations are, and who to go to if they have a question about a policy or a vacation or a benefit. And an employee can become disengaged when there's a lack of communication and a sense that management is unable to answer the question. So it's imperative to have a resource you can reach out to. So that gets me to number one. We hear you need to know employment law, but it's important to know your employment law. And we look at employment law on a layered level, right? You have federal, state, city, county. And here in California, this applies quite often. And you want to make sure that you are applying what is most generous to the employee. And you want to look at your employee count. And there's certain industries that have different mandates or requirement. Those are those farm workers or live-ins. So handbooks. I get this question quite a bit. Do we really have to have one? And my answer is you don't have to have one, but you need one. And a properly constructed handbook or policy manual is going to provide clarity to your employees regarding your policies and expectations. And a handbook provides the opportunity for an employer to give their mission and values. You can list your benefits, your vacation, your holidays, what are paid, what is not paid. You can communicate to your employees about what behavior that's not acceptable, meal and rest breaks if it's applicable, and harassment policy, the time off, who they contact if they have a question. And an employee handbook is the best way to avoid misunderstandings and ensure fair, consistent treatment with your employees. I have reviewed several employee handbooks where companies have taken a friend's company handbook and copied those items, or they've downloaded one from the internet, only to find that the policies were outdated, did not apply to their organization, and actually some sections were left blank. So you just want to make sure that this information in your employee handbook is relevant to your place of employment. And not having that employee handbook or policy manual puts you at that disadvantage to defend yourself should you face a lawsuit. In California, our legislators love to make changes every year, and I know some other states are doing the same. So keep that handbook updated. Have a resource where you get a regular email, especially when it gets to about October, November, you should be getting those about changes that are up and coming. You want to make sure those stays updated so your employees know if anything updates, and the one that's using it to comply is aware of those updates as well. So additional documents. First, should you choose just to use a handbook and nothing else that's optional, you want to present that handbook to the employee on the first day. Go over those important parts and policies of that handbook. Have the employee sign something that they understand, and you want to make sure you document it. And documentation is key. Here we have additional items. So the offer letter, what's important about that is it provides you that contingent offer statement. This offer is contingent upon a background check, a drug screening, references, etc. A job description. So a job description is basically a legal document that's used to evaluate performance. And what's interesting is the Fair Labor Standard Act, that's the FSLA, which we'll talk quite a bit about, nor the Americans Disability Act, the ADA, neither require a job description in their regulations, but in fact, if there's a dispute, it's going to be essential in defending your organization and in defending that reason for termination. A job description, and we'll talk further on, should be a part of what you provide that applicant when he or she arrives to apply for the job, and also on that first day, have them sign that and put that in their file. Job applications, I know many are online and some platforms provide it, websites. Just make sure it's compliant and compliant with your state. The difference between a job application and a resume, should you still have employees come into your office or have an applicant come into your office, is that application signed. So it's documenting that those facts are true as to where a resume is not. Compensation records, warning, incidents reports. Compensation records, anytime you're going to give somebody a merit increase or any increase at all, make a note in the employee's file as to why. Because if there's a reason somebody else did not get an increase and they want to come back and say it was based on discrimination, you'll have that as to why that person received one and possibly why the other person did not. Incident reports, good and bad, you want to write those down. Doesn't necessarily mean you have to talk to the employee, but you want to make note of it. Supervisors like to come in and say, I'm done, it's time for that write-up. And they can recall situations, but they don't have specific times, dates, and what exactly took place. So when you have supervisors and managers have those incident reports in the employee's file, it's easy now to go back when you do that write-up and you have those exact specifics. So I-9, I know we're going to have a little poll question here, but that's that employment eligibility verification requirement. And Zach, if we could just throw a little poll out there for everyone. So how many days does a newly hired employee have to present documentation for the I-9? Where we're at. Great, that is, well, actually, could be a little bit of a trick question. It's actually 3 days. So to complete the document, that page that the employee completes is day 1, right? But for the documents that's needed to prove eligibility and authorization, or they say who they are, is 3 days. So let's say an employee starts on a Monday, that employee has no later than Thursday to present those documents. You want to make sure that, excuse me, another little tidbit is there is the Spanish version, and that Spanish version can only be completed by employers and employees in Puerto Rico. In the remaining states, you can use the Spanish version as a reference, but you must complete that English version. The W-4 and other state tax filings, I think it's important to make sure that any employee makes a change through the year on their tax filing, have them refill one out and keep it in their file. And make sure you're providing those pamphlets and posters anytime upon hire, upon a termination, a leave of absence. And those required posters, a lot of those you can get through your payroll company. You just want to make sure that they are current. Oh, there we go. Sorry about that. Okay, so this leads me to this. So let's now hire that employee. So give the truth when posting a job. The way job posting it's starting to change. It's no longer the old way. Typically, we start that posting about the company and we state we're looking for a team player, a multitasker, or a highly driven. What does that mean? And to each of us, that level of understanding and meaning is different. To my husband, making a sandwich and talking to me is multitasking. To me, answering the phone and filing and responding to an email all with 1 minute, that's multitasking. And so there's different understandings. So you want to be very clear. And there is an element in the job description. There are elements in the job description that is relevant when placing an ad, but the job description should not be your ad. The job posting is a marketing version of that job description. And that job description is that legal document that you want to keep in that employee's file. So the job posting is created to attract the right person. You want the outcome to be, yes, I can do that job, or no, I don't want to. And you want to clarify posting so a stranger can read it and know what it means. So when creating that ad, think about what your best employee does and build from that in that position. What's the impact of the work? What is the everyday activities? And don't be afraid to actually list the day-to-day activities and what that looks like. You'll be servicing 10 residential homes and driving within a 75-mile radius. Give them the truth. If there's no mandatory requirements, don't put any. You can just put something like, if this position is truly an entry level, you can put something that says you don't need any specific qualifications to qualify for this role. We'll teach you everything you need to know. And keep your ads to about 250 words and no more than 7 bullet points. And this is based on a social media study that stated that after about 250 words, that you lose the interest of readers. And same with bullet points. So keep that in mind when you're doing that. And when you're talking about the company, save that for when you're interviewing them, and then you can be more detailed about that. You want to draw these applicants in because you want them to be able to do the job that they're qualified, not because they think your company is cool, right? Properly classifying employees, or you want to properly classify employees, and here's where a lot of employers get into a bit of a quandary and end up paying out quite a bit. There's this misclassification of this non-exempt and exempt, and I'll explain that. Non-exempt is a not exempt from overtime, right? They get overtime. An exempt employee does not. Now, I'm only going to stick to federal in this situation, but under federal law, a non-exempt employee will get overtime anytime they work more than 40 hours in a work week. And an exempt employee is going to be this salaried employee and meet certain job duties. And where a lot of employers get, they think that they can just give a title, a manager or supervisor, and that gives them the okay to place them as a salaried employee and not pay that overtime. And that's not so. If you go to the Department of Labor's website, there is menus that you can look at different classifications for that. White collar worker, they call it, administrative, professional, executive. Look at the duties. If they meet those duties and you can meet that minimum salary for a week, then you can classify them as that exempt employee. Otherwise, they're non-exempt. They're hourly and they get that overtime. When it comes to independent contractors, I'm going to talk that in a couple of slides. Don't classify somebody as an independent contractor just because it's cheaper or they want to. Don't want to do that. And we'll talk about that more here. So again, exempt versus non-exempt, right? Duties is important. The job titles irrelevant. You have that minimum salary requirement. For federal, that salary level is going to be that $684 per week. It needs to be provided regularly on a fixed basis, and you have that duties test that they need to pass. So independent contractor, again, you can go to the Department of Labor's website and get very detailed in regards to this, but this is just a quick overview. And I like to look at it this way. Somebody who's an independent contractor, are they a DBA, right? Do they have their own business? Do they have business cards, website? Can they decide when and where they work? Are they using their own tools and equipment? Can they work for multiple clients, not just yours? And they get to decide what work they will do for you. So keep that in mind. I understand that people will say, just pay me as a 1099. It's fine. It will be fine. I'll be happy. You'll be happy. And 9 times out of 10, that isn't usually what happens. They'll get that tax bill and now they're not so happy. So don't do this. Make sure that you're following the guidelines under federal, and some states have their own as well. If you're still unsure, the IRS has the form that you can download from their site, complete it, submit it to them, and they will officially determine the worker status for you. Wage and hour laws. I'll just touch a bit on this. The FLSA, that's the Fair Labor Standards Act, under a federal law, they have certain criteria, and then we also have state laws that may have something different. So you want to make sure that you're looking whether your state law is different than federal, or if you're governed under federal. Under federal, does not require a meal and rest period or rest breaks. Many state laws do, and California we do, and it's very strict. Overtime for federal, that's that 1.5 times over 40 hours in a work week, and I'm going to talk about that work week. And in many states, California, of course, we have to pay anything over 8, and then we have anything over 12. And when we define a work week, this is what's difficult. The FLSA and states will say, you need to decide, what is your work week? Is it Monday through Sunday? Is it Sunday through Saturday? Figure out for your business what your work week is. And don't worry about the hours that you're open. This is the work week for it to determine overtime. And where a lot of administrators get confused is if you happen to have payroll periods that fall in the middle of this week, you want to make sure that you're still looking at that week, even if some of those hours were in that last payroll, and whether that employee ends up with over 40 hours in that work week. Excuse me, so that employee will still be entitled to overtime. Tracking of hours worked. This is a requirement under FLSA, it's a requirement under state law. I know that Field Routes within their platform, there's the ability to track hours worked for hourly employees. Excuse me. You can, the Department of Labor has an app. You can download and use that for free. There, you can have your employee use paper. However it is, you do need to track their hours. And I will tell you, if you do this 12 to 12:30, 12 to 12:30 for lunch consistently, that's a huge red flag. And if you get audited and they happen to look at that, it's going to be a sign that those employees are not taking lunch. Zach, am I good on time?
Yep, doing great.
Thank you. All right, so lawsuits, I just want to touch a bit on this. So we talked about those wage and hours and classification of employees. And under a federal court order, this operator of this Dairy Queen had 19 franchises. He was paying his managers a salary, and he classified them as a salary. problem is that that salary did not meet the requirements under federal law. It was less than that. So he ended up paying, because they had to go back and pay them for overtime and all hours work, he ended up paying them this $358,200. There's about 7 managers in this lawsuit. This other lawsuit, this Lido Bar and Grill, I believe this may have even been in California. The owner of this company thought she was doing her employees a favor. So what she did, anytime that they were working overtime, she paid them cash. But the problem is that when she paid them cash, she paid them at straight time. She thought she was doing them a favor. It's cash, you're not paying taxes. And the workers, it was fine when it was happening, and then somebody filed a lawsuit. So she ended up paying this amount to them as part of the penalty. And what she ended up paying was this $81,577 in the back wages. And then she had that same amount that was for damages. And then she had also an amount that she had to pay in penalties. So make sure you are classifying and paying correctly. All right, so they're properly reimbursed for business expenses. The federal law really doesn't have anything that in particular that states that you must do a reimbursement. State laws do, city state laws do, I should say. But under federal law, you want to look at this, especially now with many employees working remotely. So if you have an employee who's at that minimum wage or just slightly above, working remotely, and their expenses, their internet, their pens or pencils, and if they look at the cost of that and what they're spending, brings that federal minimum wage down, then that's what's considered a kickback and under FLSA, and that's unlawful. Another example is if there's a delivery driver, he makes maybe slightly above minimum wage, and now he's paying for fuel, vehicle needs to be repaired, and when you look at that based what he makes, and it brings him below minimum wage, that too is going to be considered a kickback. Now, state law, they're more aggressive, and click on here so you can see this. From the east to the west here, California to New York, California, everything needs to be reimbursed pretty much, or a reasonable reimbursement. And that's kind of this mixed use. So let's say somebody has a cell phone, and that cell phone is unlimited plan, but they're still using it for work. Here in California, you still need to do a reasonable reimbursement for a portion of that use. You go to New York, they're pretty close to California in this reimbursement. But what I found interesting was that any reimbursement not made within 30 days shall be found guilty of a misdemeanor. So they're pretty strict there. So you want to, again, look at your state requirements. You want to make sure that you have a written plan and a written policy for your remote workers, what they can and can't purchase. You want to provide company equipment when possible. Evaluate what expenses are incurred, document your reimbursement, why you reimbursed for that amount, and make sure you itemize that on the pay stub if you're going to reimburse them on the pay. All right, so comply with leave laws. This gets difficult for many employers, right? There's so many leave of absence laws, and there are several laws that can potentially apply in more than one situation to an employee dealing with a medical issue or a family member's dealing with a medical issue, pregnancy, baby bonding. And I'm not going to go into different types of leaves. We'll stick with a couple here, the ADA and the FMLA, and I'll explain those. Under federal law, we have the ADA, that's this Americans Disabilities Act, and it applies to employers with 15 or more employees, and that's this reasonable accommodation, which I'll talk about in the next slide. We have this FMLA, that's this Family Medical Leave Act, and it applies to employers with 50 or more employees in this 75-mile radius. And it gives you 12 weeks of protected leave. It's not paid leave, it's protected leave. And the interesting thing about this, when employers look at this FMLA and they think, okay, 50 employees, 75 miles. Nope, I don't have anybody working within 75 miles of the office. What you want to look at is if you have field employees, it's different. So it's going to be, where do they report to? Where do they get their assignments from? So if you have one location and your field employees are out in the field, different areas all over the place, but they get their assignments from one main office and there's 50 or more employees, this FMLA will apply to you. So you want to make sure that you're really looking into the laws to determine whether they're applicable or not to you. And that 50 employees is going to go back to like 20 calendar work weeks in either the current year or the previous year, so you can kind of see who's been on your payroll. You know, many states have sick leave laws. You want to make sure that you're being compliant about that. And you want to make sure that your policies are up to date. And then you want to look at each leave individually to see if there's more than one set of laws that apply to a certain situation. So complying with the obligations pertaining to employees' disabilities. Here, a lot of times employers too will think that they can't make a reasonable accommodation. And I want to touch on this because two things. One, I want to explain when we talk about a reasonable accommodation. And also, when we talk about somebody who's been on that FMLA, so potentially you have 50 more employees, an employee's been on that leave for 12 weeks and is unable to return back to work. You're like, sorry, your 12 weeks of protected leave is over. There's nothing else for you. And that's not so, because now here's where that ADA is going to kick in. Because now that employee maybe only needs 2 or 3 weeks. And now that's going to be considered potentially a reasonable accommodation for that employee to have those extended weeks out. So you want to make sure you're looking at all the laws that may pertain to somebody who's out on a leave of absence, and then also with some sort of disability. Now, with somebody who's looking for a reasonable accommodation, that could be something as simple as somebody's in a wheelchair and they just need a higher desk or a clear path. Somebody with PTSD, they just need dividers around their workspace. Somebody with carpal tunnel just needs a different keyboard. So these could be all reasonable accommodations in certain situations. And don't think that you have to just take the word of it from the employee. If it's something you can't see that the employee needs, ask for that medical documentation from a medical provider. And you want to make sure that you're using one of those forms that's compliant in your state. The medical provider will, in a sense, let you know what is needed for that employee. And you want to engage in that interactive process in the beginning. You want to have that back and forth dialogue. There's a lot of mistakes that employers think you only need one conversation, and that's not the case. Even after you make an accommodation, you want to go back and talk to them. Does that accommodation need to be changed? Has something changed with that employee? Failure to consider the leave will get you in a lot of trouble. Claiming an undue hardship without really analyzing that. Two scenarios. If you're a large company and you have to purchase a new desk, okay, the desk is $500, but does that really create an undue hardship? Does it impact the company on a huge financial level? Will it take your profits down to nothing? You're going to have to look and analyze that for each situation. Now, if you're a business owner and you have 2 employees and you have employees in the field, and having somebody making a change and only allowing them to work 3 hours a day, that could be a huge impact on your company. That could be considered an undue hardship because you need to service those customers in order to have that reoccurring revenue come in. So just make sure you audit your policies and conduct an analysis on a case-by-case basis. Not any two are going to be alike. So promptly and thoroughly investigate complaints of harassment and bullying. Under state and federal law, employers have to conduct a prompt, thorough, and impartial investigation when the employer knows or has reason to know of potential harassing, discriminatory, or retaliatory conduct. And many employers fail to comply with their obligations under this law, or for some reason, they just decide not to investigate. And in most circumstances, companies will be held liable for your acts of your employees, vendors, and your independent contractors. So you want to make sure that you have a policy in place. People know who they need to go to complain about a situation, and that you investigate each situation. And I'm going to tell you a little bit of a lawyer had shared with us that she had actually defended, this was just recently in California, but she had defended a hotel in a case where the employee, she was a clerk at the front desk, had complained about a gentleman who came in, a guest who frequented the hotel, about him harassing her. And he would say things like, you know, your hair is beautiful and you're exotic, and you know, I'd like to get a hotel with you and do X, Y, and Z. And she complained actually to 3 different management staff, her immediate supervisor, somebody above that, and then another manager. And none of them did anything. One of them actually told her, well, you know, if it happens again, let me know. And so this, until the gentleman came back again, and this time something was wrong with his room. Either the room wasn't ready or there was an issue, but now he threatened to kill her and told her that he was going to chop up her body and bury her in the desert. And finally, somebody noticed, somebody there at the hotel, and they got HR involved, and they took out a restraining order against this gentleman, but it was too late, because this employee not only was scared, he had threatened her life, she was frustrated, she was angry, so she filed a lawsuit. And it never went in front of a jury. They did settle, but this should not have happened. That should have been investigated, and something should have been done early on. And that's why it's important when somebody comes and complains to you or to a supervisor, that a supervisor or management understands that they need to go to HR, they need to talk to somebody. So you want to make sure you have that compliant anti-harassment policy. You want to train your managers and supervisors. You want to immediately investigate. That's important. If need be, if it's somebody that's higher up in the company that they're saying that there is harassment happening, I suggest you get an outside investigator involved in those, and don't retaliate against that employee at any point when they filed a claim or made a statement. And it doesn't always have to be in writing. You don't have to wait for somebody to come and give you something in writing. A verbal statement should prompt you to begin that back and forth dialogue with that employee. Here in California, we have training that has to happen every 2 years with supervisors, employees. So in some other states, I believe there is a training for harassment as well. Please make sure you're staying compliant with that. That will protect you should an organization have to go to court and defend themselves. So I just want to kind of wrap up a few things here. As far as best HR practices, make sure you have that employee classification correct. Very, very important. Communicate your policies and procedures. Make sure everybody understands or who they can go to should they have questions. Sign documents, sign. Have everything signed. That job description, that last page of that employee handbook. If you have additional things, vehicle policies, cell phone policies, you can have a drug policy, have all those signed, keep those documents. Be consistent with all employees, treat them fairly, consistently, and respond to them when they have a situation. I did mention that I want to give you some HR resources. Of course, there's me. I do have my platform that I broker, but there is Fisher Phillips. They are across all states. I love listening in on their webinars. Their webinars are free. You can sign up, go to their website. You can see all the webinars they have up and coming. Great information. The SHRM, that's another area that you can get information from. You can also sign up with them. Those are for all states. That's a great resource. Same with Littler. Littler is another location that you can go to their website. and sign up for free webinars. They are 2 across all states. Here in California, if you need an employment law or want to join in on some of their free webinars and training, the Shaw Law Group is a great resource as well. That's actually the lawyer that I contract with in certain situations. And so they're very helpful. They have training and investigation as well. One other thing that you can look at is your EPLI insurance. And that EPLI insurance, if you have that, that insurance can protect you in certain situations for like a wrongful termination. But normally they'll give you access to an HR resource and training during that policy period. So potentially you could look into that. And hopefully, Zach, maybe we can share this at the end, or somebody who'd like copies of the slides. Here are some of the websites that you can go to. You have that OSHA for the state plans, AccuSource. When it comes to situations, things that you can ask and not ask on applications, they have that ban the box laws, and you can look into that. The DOL has great on misclassifications and that the salary for exempt, non-exempt. You have the IRS forms as well, and a couple of other ones like that contractor employee. And this last one actually gives a list of samples of all the recent wage and hour lawsuits. And I'll tell you, when you go to their website and you see how much money these employers have had to pay, it's quite a bit. So again, there's my information. I know that was quick and I kind of had to get through that quickly, but I just wanted to give everybody a little bit of information and some additional resources, maybe they can reach out. And then if we have time for any questions.
Tammy, thank you so much. That was a lot of great and helpful information. And like you just said, I'm guessing our audience probably does have some questions for you. So everyone, if you haven't done so already, go ahead and submit any questions you have for Tammy using the Q&A icon at the bottom of your screen. Tammy will answer as many questions as possible in the time that we have left. And while you guys are doing that, I'll ask that Zach, our moderator, post a link in the chat to sign up for a free demo of Field Routes. For anyone who is not already a Field Routes customer, this is a great opportunity to experience our operations and marketing suites firsthand. He's also going to post a link to learn more about California HR Connection. So our first question is, let me take a look here. Let's see, training managers, where do I get the training to give them?
So a couple of resources. If you're looking on safety, if you go to any of the OSHA websites, and if it's any of your state OSHAs, they do have training there. You can also get training from a certified HR consultant in your state. And also on some of these HR platforms, there is training and videos that can happen as well.
Perfect.
And again, it depends on what state and what the recommendations. And I'm sorry, real quick, if you're in California looking for training for harassment, there is a free training for employees on the DFEH website. And instead of hiring an outside consultant to come in, you can get that free harassment training through there.
All right, thank you, Tammy. Number 2, our second question. If I have a signed contract from someone who wants to be an independent contractor instead of an employee, is that enough and would it be legal?
No and no. It's great. You know, I do hear this all the time that somebody will come in and say, no, I want to be an independent contractor. And as appealing as it may seem at the time, because you don't have to pay payroll taxes and workers' comp, if that's applicable in your state, it will come back to bite you. It normally does, and that's what I hear. But no, even if you have a contract, you do want to go to the DOL's website. You definitely want to look at those the difference between that independent contractor and employee, and just follow those guidelines.
Great information. Next, what if an employee refuses to take a lunch break? Do most states require meal and rest?
And looking at the other states, no, not all states do, and I can't even say most. Here in California, we are required to afford them. And when we say afford, meaning you have to provide them the opportunity to take that lunch. We get it that if you have field employees, you can't follow them around and say, it's time to take your lunch. But what can happen is, and what you should do is when you've afforded them to take that lunch and that employee has not taken that lunch, you want to document it on the timesheet that the employee chose not to take the lunch. You want to counsel them and have that documented, because should that employee come back and want to sue you for those lunch and those meal and rest periods, you're going to have documentation. You're going to have it in your policy that you need to take it. I know it's difficult, especially in the service industry, to get employees to take those lunches. Again, they don't have to, they should, but if they don't, as long as you've afforded them, and document when they don't.
Thank you. And our final question, if an exempt or salaried employee works part-time, can the salary level be lowered?
No. So the FLSA, the Fair Labor Standard Act, it has to be a set amount. It's not based on the amount of hours worked, and that's why you don't have to pay that overtime. So it has to be the same amount. It cannot be reduced at all. And that's even for here in the state. In California, if we have any listeners from California, our requirement is 2 times the state minimum wage, not our county, not our local, but it's 2 times the state minimum wage. And that's going up again. So keep that in mind.
Great. Well, that's all the time that we have for today. We want to thank you again, Tammy, so much. We really appreciated you joining us today.
Thank you. Thank you for everyone and taking the time out of their day to listen. Hopefully that was good information. I know it's a lot in that amount of time.
Absolutely. We appreciate it. And thank you to all of our attendees for joining us. We hope that you found this valuable, and remember to watch your inbox and social media feeds for information on our upcoming growth and tips and tricks series webinars. Everyone have a great day.